Sorry. Good afternoon and welcome to the Appellate Division First Department. I am going to call out the calendar if you'd let me know how much time you need. Remember that we have had the briefs and the records, and so we are familiar with your cases, and we just want you to get to the really nitty-gritty and the heart of your cases. So when the red light goes on, you should finish up your presentation. If we have additional questions, we won't be bound by the red light. We may continue to ask questions. Okay, so the first case for argument today is People versus Pedro Gill. Okay, I'll give you 5 and 2 and 5. Thank you. Civic versus City of New York. Respondent? Okay, I'll give you each 5 minutes. Total environmental versus contract dispute? Okay, I'll give you 6, 2, and 6. Thank you. People versus Juan Medina? Okay, that's submitted. Hurley versus EB Safe? Okay, 5, 2, and 5. Thank you. Police Benevolent Association versus the City of New York. She said, she asked for 8 and 4. It's a little more than I'm going to give her, but. You have a cross appeal? Okay. We'll do 6 and 2 and 6 and 2. Thank you. People versus Mahoney?
Respondent request 5.
Okay, 5, 1, and 5. Thank you. Song versus Yorkville Towers? The appellant did not request time, so do you still want to argue? And you're Yorkville and you're Greater New York?
Yes, sir.
Okay, does anybody have any questions to ask? No? Okay, then we'll, if that's okay with you and you agree, we'll take it on a submission. Thank you both very much. Just wait till the end of the calendar call. GNY Maintenance versus Core Continental. And is there a respondent? Okay, so let's do 7 and 2 and 7, and if we have additional questions, we will ask you that. Please be seated. Thank you. Bloom versus Hilpert is submitted. Lang versus Brosnan is submitted, and YH Lex Estates is submitted. That concludes the call of the calendar. The first case for argument is Pedro versus People versus Pedro Gill. Somebody else did. I'll try to read it. Good afternoon.
Good afternoon, Your Honors. May it please the Court, Natalie Ray of the Legal Aid Society for Mr. Gill. The question in this case is whether the officers had probable cause to search the car, not the driver, but the car. We believe the answer is no. To have probable cause to search the car, there had to be some objective fact showing a nexus between the crime of arrest and the car. Here at 191st Street, all we had was an aborted, alleged, possible future drug transaction that did not provide the additional evidence necessary to provide the nexus necessary. There was no evidence that my client saw Mr. Herrera approach the car from the back, allegedly with some money in his hand.
What about what happened prior to him going to the car? The 2 incidents where he observed him going to the car and taking something out as part of the overall transaction?
So we don't believe that combined with what happened what happened at 184th Street was sufficient. Why? All that was seen at that point was the officer saw basically hand gestures. This court in New York, there's a very minimal requirement to decide whether there is a reasonable suspicion or probable cause of a drug transaction.
Why is this case different, though, than many of the other cases we've had before, where they've seen similar gestures, and we've upheld that as the observation based on the officer's experience of a transaction involving the sale of drugs?
But none of the
Why is
cases,
this different in those cases?
because none of the cases, in none of those cases cited by the people, there must always be, at the very minimum, and it's not too much to ask, either money seen or an object that's drugs, not gestures.
What's depicted in People's Exhibit 2, the photo?
The photo that was, what's exhibit, this morning, the court asked for the DA to send the photograph. And what that shows is basically, it's to show the capability of the binoculars and magnifying by 8. It's not showing what happened or what the situation was like at 9:30 at night on the day of the crime. It's simply to show how much
Is this picture taken at night?
No, it's taken, and in fact, I will, during the voir dire of that picture, the detective testified that, of course, it was nighttime, so it's not the same. There have been more cars. There may have been more people. It was a summer night.
But is this a fair and accurate representation of what the officer could have seen from the binoculars from his stakeouts or her stakeout scene?
No, because there's nothing there. All that shows is how magnified it was. If it was so clear, then I think the situation is even worse for the people, because then the officer should have seen more than what he was capable of describing. He didn't see whether my client has his legs in and or out of the car. He couldn't see. The key to what happened at 100...
Because the magnification is quite striking.
It is, and therefore he should have seen more than what he was capable of describing, which was virtually nothing. In fact, when asked whether he never saw, we know that it's a drug-prone area and that he has experience. This court has said that's simply not enough. When asked about the money, at some point he talks about seeing money or a piece of paper. In fact, he says, he saw what looked to me to be money, a piece of paper. Could not see if it was really exactly money. Money or a piece of paper. It looked like a piece of paper. It was night, it went fast. So,
Counsel, over what period of time did this transaction occur?
How long did it take?
During that observation of what the officer believed may have been money.
He said it went very fast. Both transactions went very fast. And in fact, when asked to explain what he saw, he said, I don't know. I just see an arm extend. I can't tell how far. I don't understand. I don't know how to explain it. Went very fast. But what I want to say is simply, if, first of all, the officers knew they didn't see enough to stop. Because if not, they would have stopped them. If they had had reasonable suspicion, they would have stopped them when they got down to the street and saw my client go into the car. They didn't. They didn't because they knew they didn't have enough information to stop them. And they followed.
I don't know that that's a fair conclusion. I mean, they want to see where this is going. I mean...
They can, maybe. But when they did, may I answer?
Yes, please.
Sorry. It's maybe not the only conclusion, but if they wanted more information, then why did they interfere with the next alleged transaction that they wanted for more information? They just had to wait 2 seconds. I'll add on.
Okay, you'll have a few minutes on rebuttal. Thank you very much, counsel.
Good afternoon, and may it please the court. Faith DeTrolio for the people. This court should affirm defendant's conviction. The hearing court properly concluded that the officer had probable cause to believe that he had just witnessed defendant engage in 3 completed or almost completed drug transactions out of his vehicle. That probable cause came from a few things. First, the officer had extensive experience and knowledge of drug sales and the drug-prone area. But more importantly, the officer testified that he saw specific hand motions that indicated to him that defendant was passing small objects to the purported buyers of the drugs.
Did the officer say that he also observed money or something that appeared to be money? How did he explain it?
Yes, he said that he saw what appeared to be money, I believe, in the first two transactions. And in the third transaction, he did see the person holding money. He was much closer. But as Your Honor indicated, the photos submitted to the suppression court and to this court show that the detectives could have seen from the roof what appeared to be money. They had binoculars that were 8 times the magnification power.
I mean, counsel makes a point that this was taken, it sure looks like it was a bright sunny day, and some of these transactions, or this transaction was going on in the evening. I think that makes a big difference.
Sure, but the officer did testify that the area was very well lit at the time of the transactions. There were street lights, there were lights from the stores. On top of that, the detective saw a repeated pattern of this conduct. He saw this happen 3 times. And beyond that, when they did approach the third vehicle, the co-defendant did back away very quickly from the car and try to separate himself. So in the totality of the circumstances, they had probable cause to arrest defendant. And that probable cause gave rise to the ability for them to search the car as well. They saw the defendant specifically going to his car in the first 2 transactions to conduct his business. He was standing with his friends on the corner and then moved away from them and sat in the car to conduct these transactions. So that gave him the indication that there would be contraband or other evidence inside the car. And so, yes.
So defense counsel makes the point, why didn't they stop for the 2 transactions that they saw from the roof trap, and instead they follow in the vehicle? What's your response to that?
Well, they weren't required to stop them after seeing the first 2 transactions. Additionally, I believe that by the time they got down from the roof, the defendant and the co-defendant were already driving away, or a few moments after were driving away, so they decided to pursue that further. But they weren't required to stop them after seeing the 2 transactions. If there are no further questions, we ask that you affirm.
Okay, thank you.
Yes, they were. This is simply not a case of 3 drug transactions and a third person saying, oh shit, when he sees a police officer. There was, at some point, there was no, the people rely on his experience and the drug-prone area. This court has made it clear that if that's the standard, then the possibility for abuse is a lot, is too much. And we are forgetting the necessary nexus with the car. The car exemption is an exception to the warrant requirement. There has to be something there. Nowhere, and no one is claiming.
But I mean, I agree that it may have been a concern if it was just a drug-prone area and it was just because this officer had experience. But the fact that he did testify that he saw someone come by, hand something in a small package in exchange for what appeared to be money, and he saw that happen 2 or 3 times, I mean, isn't that entitled, you know, when you take that all together?
The court says no, that some
cause?
of it has to be either the object or the drugs. I want to go back to these photographs 1 second, because if it was that clear, right, as you could see from Exhibit 2. I mean, then, first of all, they do say there was no van, etc., but the officer should have seen more. And although they were not required to stop them, what officer would not, and instead of letting the person go off by car, the whole point of the car exception is, oh, you don't want the car to go away.
She said it's not that they let them go off by car, it's just he went off by car. They had to get downstairs, didn't they?
And I want to correct the DA, they were not in the car when they got downstairs. My client was entering the car on the passenger side. And I also want to note that there's absolutely no evidence as to the 191st Street that my client saw anything. Thank you very much. We would ask you to reverse.
Thank you. Thank you both. Next case for argument is Civic versus City of New York.
Good afternoon. May it please the court, your honors.
And counsel, what is your name, please?
Michael Manusos.
Thank you.
Thank you, Madam Justice. This is not your typical trip and fall street crosswalk case because this happened within 12 inches of a manhole. And that triggers.
Did the accident or incident have anything to do with the fact that the manhole was there?
No.
So why does it implicate the manhole cover rule if that had nothing to do with the accident, and the accident, as alleged by the plaintiff, was because of a pothole?
Yes. Pursuant to 34 RCNY 2-07B, and if we can just call it the manhole law, it states that owners of manholes and grates are responsible for the surrounding surface extending 12 inches in diameter. This particular pothole, if you want to call it a pothole, it was a paved blacktop area around the manhole, and there was a broken piece of roadway with a depression and a height differential. So we can call it whatever we like, but for purposes of right now, we can call it a manhole. Therefore, the city of New York, of this New York City sewer manhole, is responsible. So this is not your typical 7-201 case known as the pothole law, because 34 RCNY 2-07B triggers, kicks in, and it has an affirmative legal mandate that says the owner of the manhole, here the city of New York, shall monitor, repair, and maintain. The city produced no evidence whatsoever that it monitored this manhole. Therefore, it can't make out a prima facie case with respect to that because it violated its own law. The city argues that the Obler case that this department produced is controlling, but it is not, because this department in deciding Obler did not at all address 34 RCNY 2-07B didn't address it at all.
Sir, did the second department address that issue in Gorey?
Yes, Your Honor. Yes, Your Honor. That is, to my understanding, the only appellate precedent. The problem I have with that, Your Honor, is that there is absolutely no reasoning, no clarification, no analysis vis-a-vis the clear, plain mandate, the language, the content of the manhole law. And it did so say that the manhole law did not obviate the pothole law, but it did so without any legal precedent on point, without any analysis, without any reasoning whatsoever.
And do you have any precedent to support your argument that the manhole law did not relieve plaintiff, that the manhole law relieved plaintiff of the obligation to prove prior written notice?
Yes, Your Honor. No, there isn't, but that's the problem that I have exactly, because it places an undue burden. It creates something for the plaintiff here, for the appellant here, to produce something that doesn't exist. If
that was the law, then there would be a case that states that's the law. So I'm not sure I'm following your
If
argument.
720,
We're talking about case law, case authority. If there's no case that holds one vitiates the other, and there is a case that goes the opposite way, why is your argument more compelling?
for two reasons. Your Honor, number one, this department, I believe in Flynn, has held that the manhole law, 34 RCN 2-07B, is not supplanted or superseded. In that case, it's 7-210. So the argument that I submit to you by analogy is the same should apply to 7201. If I may, one more sentence.
Sure, go ahead.
The problem that I also have with 7201, it doesn't have any preface or conditioning or exempt language. For instance, you find in the rules and laws and regulations that notwithstanding any other provision of law, the city should not be liable for any defects in the roadway without prior written notice. 7201 does not say that.
Okay, thank you, counsel.
Thank you.
Good afternoon, Your Honors. May it please the Court, Jonathan Popolo for the city. Your Honors, the Supreme Court properly granted summary judgment on lack of prior written notice grounds here. I mean, that is the issue that's before the court.
And are you aware of any case law that defines any relationship between the manhole law and the prior written notice?
Other than the Second Department's recent case in Goury, not directly. I guess I have two things that I could offer in addition to that. One, that maybe the Second Department did directly address this issue and came out opposite of the position my adversary is advocating. The Court of Appeals in Oberler, an argument had been made that, that there was a violation of some sort of, it wasn't this particular rule of the city, but it was a different regulation governing, I believe it was manhole covers or potholes, and so the court didn't directly address it, but it didn't find that somehow brought the case outside the ambit of the prior written notice rule.
Is there that if you say that the city has to maintain the manhole covers, that there couldn't also be, there isn't a conflict with the requirement which says that if there's a defect in relating to the manhole, that there has to be prior written notice to the city before they can be liable for that defect? Absolutely, Your Honor. I mean, prior written notice is a condition precedent before you even get into what. It's consistent to interpret them. There's no inconsistency between the two provisions. That's correct, Your Honor.
Is there any claim by the plaintiff in the Bill of Particulars that the plaintiff's fall was caused by the manhole as opposed to by a pothole in the crosswalk?
I don't think so, Your Honor, but just to be clear, the plaintiff referred to it at her 50H hearing as tripping in a pothole. But I mean, there is, and she described it as two ovals, and there are pictures. It's a depression that she described as a pothole that's near, and I don't have any reason to dispute that it was within 12 inches of a manhole cover. But, so that's it. There was this, I don't think that the plaintiff referred to it as a pothole.
I mean, there are two depressions or potholes, however you refer to it, close to a manhole.
Correct.
But the map that's in the record doesn't show that that was ever reported to the city.
Correct, Your Honor. I was also just going to mention that Flynn is, the other case my attorney mentioned, is inapposite because, one, it didn't deal with this alleged conflict with prior written notice. It was a situation where it was a 7-210, which is the provision of the administrative code that imposes liability on the abutting property owner for the sidewalks. And the issue there was, you couldn't look, there was no intention that the provision of the rules that talk about the owner of the manhole's cover's duty to maintain the 12-inch radius, that somehow shifted the duty from the owner of the manhole cover to the abutting property owner. So it has nothing to do with the issue that's before us here. I don't, if Your Honors don't have any further questions, we'll rest on our brief.
Okay, thank you. You didn't ask for it, but I'll let you have 1 minute. 30 seconds. I can't set the clock for 30 seconds, so you got a minute.
My apologies.
That's okay.
With regard to what my good adversary mentioned in Oberler, with regard to a design and construction regulation, this court said in Fazzolari, which I don't believe is in the brief, that regulation does not contain a particularized mandate or a clear legal duty, unlike 34 RCNY 207B.
Okay, thank you. Thank you both very much. Okay, the next case for oral argument is total environmental. I actually am recused from that case, so if there is a tie, for any reason, a fifth judge will be vouched in. Got it? Yep.
My name is Claude Millman. I represent Total Environmental Restoration Solutions, which I'll refer to as TERS. There are two issues here, both flow from the same clause of the same contract. You find that at page 805 of the record. And it concerns the pricing provision for two separate tasks, and the pricing provisions are different. The first task is remediation and surface cleaning, and that is priced at 3.6 pennies per page. And the second is for scanning and digitization, and that is priced at 4.2 pennies per image. These are low prices because the competitors demanded in a bidding process.
A big issue you face here is that when you do a page for remediation, for cleaning, do you count both sides or one side? Well, how do you deal with the fact that your bid, which became part of this deal, as it appears at page 815, 816 of the record, specifies that for digitization, you do count, it speaks of double-sided documents, and it says you count them as 2 pages, but you don't have a similar provision when you talk about remediation.
Thank you, Your Honor. So it's true that in the proposal, which in the contract is the second least most important document in the contract, there is a section called scanning. It is not a pricing section, and that section does not define any word. It doesn't define image, and it does not define page. For the pricing of scanning, digitization, the pricing is based on image. So you don't actually need to know for that section for pricing purposes what the word page means or document means. You just need to know what image means.
It definitely is a separate definition in one section versus the other. And why shouldn't we see that as an intentional choice on the part of the parties that they were going to define page separately for purposes of digitization and remediation? And why doesn't that make sense? Because with digitization, it's 2 separate sides of a paper, but with remediation, you're just remediating the paper. So why isn't that consistent also with what they are?
So first of all, that is not a definition of image. That discussion is explaining how documents should appear in the role of PDFs. In other words, that they should be enumerated, that a document containing a double side should be enumerated page by page. That does not mean that it affects the definition of image at all, and it's not intended to be a definition of image. It's not in a pricing section. For the pricing section, you go back to the main contract. There's only one pricing section, and the word page is used and the word image is used. The panel below said that those terms were unambiguous, and so then under this court's decisions, you look to the definition of the word page, and the definition of the word page is one side of a sheet. And there is actually at page 129.
Where is the definition of the word page one side of the sheet?
That is at page 20 of our opening brief. We offer 3 different dictionary definitions.
No, but we only get to dictionary definitions if we find the agreement itself to be ambiguous. If we find the agreement to be unambiguous, we don't look to any extrinsic evidence.
No, that's not correct.
It's not correct?
Under this court's rulings, so in the absence of a dictionary definition, you look to the plain meaning. That's Carrig from this court.
But unless there's something defined in the contract itself.
That's correct. In the absence of a definition, there is no definition of the word page. Then you look to the plain meaning. If you need to find out the plain meaning of a word, then you look to this court's decision in Bianco, and that says that a dictionary definition offers you the plain meaning of the word, of a word. And that is not an external thing. We're reading an English contract using English dictionaries. So it is perfectly appropriate to use a dictionary for an unambiguous provision, and we believe the word page is unambiguous, just as the lower courts said, but we think that it means one side. And at page
it's not
129...
even, this is not even a typical contract case, because we're just trying to determine whether there's a rational basis for the CBRD. We're not in the first instance interpreting, or the trial court was not in the first instance interpreting the contract, just determining whether the CBRD had a rational basis for coming at the way they did.
Well, the standard is, did they make an error of law? Since they said that the contract is unambiguous, then the question is, what does that term mean as a matter of law? And what they're saying is that page means one sheet as a matter of law, and that's an incorrect interpretation of law. So that's a de novo question, that part. Just on my last two, I just want to mention that at page 129, it explains why surface cleaning is more difficult to do when you're dealing with a double side. Because what you have to do is, on the double side, you have text on each side. So you have to, with little micro sponges, go through and very carefully avoid destroying the ink. You don't have to do that if on the other side that's blank. On the other side that's blank, you do a quick sponge over. So there is a difference between them. You don't need to decide that or look into that, because the only question is whether the word page is unambiguous. There's a second issue, but I guess I'll get to that
You have
in
time in
rebuttal.
rebuttal.
Good afternoon, Your Honors. May it please the Court. Philip Young here on behalf of the NYPD. I want to pick up where my adversary left off. Another very important point to understand here is that what TERS had to do when they were remediating documents after they finished,
What number did the city estimate were remediated?
Sorry, say that again, Your Honor.
How many pages did the city estimate were remediated?
38 million, Your Honor.
And yet, when it comes to digitalization, you come up with only 31 million, right? Well,
that's right, Your Honor. We came up with that number based on the documents that TERS...
How could there be less pages digitalized, or I don't know if the right term is pages or documents digitalized, and more than that remediated, so many more remediated?
Well, the record is
Is there
not...
an inconsistency in those two numbers?
No, it's not necessarily an inconsistency. I don't think the record directly speaks to this, but certainly there were issues the record reflects with scanning documents due to dirt and mud and things on the documents. And so there are places in the record that explain that it was difficult and they were having problems with scanning some of these documents. So it's...
So you mean there was 7 million less documents scanned than...
Than digitized, yes, that's right, Your Honor. But just to go back to my adversary's last point really quickly, in addition to fumigating, cleaning, eliminating spores, and all those things on these documents, what TERS had to do is they had to certify that these documents were safe to handle. You can't certify that something is safe to handle unless you are cleaning and remediating both sides of the document. So regardless of whether there's text on one side or both sides of the document, you're doing work on both sides of the document to make sure it's safe to handle. And that's why the unambiguous language of the contract is the way it is, double-sided document.
The argument of opposing counsel that those definitions have nothing to do with pricing when they talk about one-sided versus not one-sided, two-sided.
I disagree, Your Honor. I think they use the same term, page, that is at issue in this contract. The language at page 816 of the record says double-sided documents count as 2 pages for purposes of digitization. And then on the very next page, TERS provides a table outlining the prices for remediation and digitization, and they use the word page in that. And then that's the same word that the NYPD also uses at page 805 of the record for their primary contract.
Well, what about what petitioner says that there's more work involved when you have to do both sides of the page, and therefore there's no reason that they should be counted? It just doesn't make sense that it's one page when there's text on both sides which have to be treated.
Well, I think because there, well, First of all, I think,
So I think that's one of the arguments that runs through your brief is, well, what's the difference whether there's text on both sides or not? If you're doing the page, you have to do the page. But he says that there is a clear difference in what has to be done depending on what's on the other side of the page.
so I'm candidly not familiar with that particular page in the record and what exactly it says, but it is clear that you have to certify that these documents are safe to handle. So you're always performing work on both sides of this page, no matter what. And so for that reason, they used one page equals one sheet of paper. And again, that's entirely consistent with the contractual language here. If we go back to what the contract says, although it doesn't explicitly define page, the unambiguous language makes clear that in the digitization context, double-sided documents count as 2 pages, and there's no equivalent provision in the remediation section saying that. And this court has held in AMBAC, in Wells Fargo, that where you omit language in one part of the contract that you include in the other, you assume that the parties made an intentional decision about that. These were
Is your
two.
friend correct that we should employ a de novo standard of review as to the definition of page?
No, Your Honor, it's not a de novo standard of review. I mean, this court has repeatedly held that when you're reviewing a decision of the Contract Dispute Resolution Board, it's an Article 78 proceeding, it's arbitrary and capricious, abuse of discretion, error of law, affected by an error of procedure. And so this court has repeatedly held that the question is whether there is a rational basis for the CDRB's interpretation of this particular contract.
But how do you address counsel's argument that the CDRB's use of the definition of page was an error of law itself?
Well, so I think it's true that the Article 78, 78033, says that error of law is one of the things that you ask when you're performing an Article 78 review, but it's still not a de novo review because the question is simply whether it's a rational interpretation of the contract or whether it was an error of law. You're not reviewing this anew outside of the Article 78 context. You're looking at an agency's determination and asking if that was rational under
Well,
Article
if your friend
78.
is correct that, assume, if you will, that your friend is correct that the contract itself doesn't define page, would we then be justified in consulting the commonly understood meaning of that as informed by dictionaries?
No, Your Honor, because the definitions that my adversary proposes are inconsistent with the language and intent of the contract for all the reasons that I just explained. And it's also worth pointing out that if you look at any dictionary, it gives both definitions. I mean, in common parlance, we use the term page both ways, depending on the context. And here, the context is digitization tasks and remediation tasks. And because those involve 2 different things, they use the word page in 2 different ways.
Thank you.
Thank you, Your Honors.
I'd like to briefly address the second issue, which is exactly as Your Honor mentioned before. The problem is that according to the NYPD, there were 38 million.
I saw you made that argument.
Yes.
And, initially it seemed like a really powerful argument, but then isn't the city's response, the police department's response, equally compelling in that they say, well, this is based on a PDF count, which I presume means they run it through a computer and get a count of the actual number of digitalized documents. So that says that's what came up in doing the count, that it's 31 million, basically.
So the problem with that is that at page 691 and 692 of the record, where the CDRB reaches its finding, it says, quote, TERS provided 31 million digitized pages, not images, pages. And then it said, and then the record support that the city points to that, they don't point to any place where 31 million pages, images are found. What they point to is in what a document called Exhibit 9, is a document that has a chart, and it shows on that chart pages, and it says 31 million pages or a little bit more.
So what are you saying? What NYPD's brief says, page 25, but as explained above, the NYPD derived the 31,010,422 number by reviewing the number of PDF pages in each of the hard drives delivered by TERS, page references, it goes on, it was an actual count of the image files TERS had created and delivered.
So what they're citing is at page 971 of the record, which does not say that. What it says, there's a chart, and it shows that number and a reference to pages, and then also 38 million pages regarding that were surface cleaned. So never does the CDRB or the supporting information reference images.
So for digitalization, is that something you run some program through the computer and it will give you an actual number of digitalized images?
We tried to do that. We offered evidence of that, and it came up with a much larger number than 31 million, but the CDRB rejected that and said there had to be an image-by-image count. And so what we've said is there should be a remand for an image-by-image count because the only document you have is a document called Exhibit 9 at 971 of the record, and it says, quote, digitization based on hand drives receives, doesn't mention any kind of count, just says based on drives received, and then it says 31,010,422 pages. I don't know what those pages are, but it doesn't use the word images, nor does the CDRB, and that's the pricing.
In the context of an Article 78 proceeding, is it something which supports our changing the result below?
Yes, under Sherbin, which is a Court of Appeals case that we cite, it says that you can only uphold the agency decision, the CDRB decision, based on the grounds asserted by the CDRB. So if you don't find it someplace in that CDRB decision where it says that there were 31 million
Basically,
images.
they accepted that 31 million number. Was that an arbitrary and unreasonable and unfounded determination?
I think, first of all, it's not a reference to images. It's a reference to digitized pages, whatever that might be. Second, it's not based on anything in the record referencing images. And if you look at the questioning by Mr. Graff, who was one of the CDRB members, he asked I believe it's, he asked the lawyer for the city what that number on Exhibit 9 reflected. And he specifically said, this is in our reply brief, is that the number of images? She said, I don't think so.
Thank you very much.
Thank you.
The next case for oral argument is Hurley versus EB Safe. Good afternoon.
May it please the court, my name is William Brewer for appellants. So as you know, appellants are seeking vacatur and remand of an arbitration award, failing to award damages based on manifest disregard of the law. I think the parties agree pretty clearly that the tribunal was aware of what's known as the wrongdoer rule in Delaware, and that it was applicable. So just briefly, in Delaware, where there's a breach of duty or a harm established, that's all that's required to award damages, and the Chancery Court and here the tribunal had very...
So you're saying that takes away the obligation, the wrongdoer rule from the claimant having to prove that they suffered damages? Isn't that still a requirement?
No, I don't think that it does that, Your Honor. I think that here there was actually multiple findings that wrongdoing and harm to the sale price had occurred by the misconduct.
The arbitration tribunal specifically make a finding that the movement didn't suffer damages.
I don't
Even
believe...
though they definitely found wrongdoing, but didn't they specifically say there was no damages proved with respect to the person who was found viable wrongdoing against.
So I don't think that that's what the analysis says. I think that they mention that harms must be established, that damages must exist, as you're pointing to. But then throughout the opinion, and part of the manifest disregard is that throughout the decision, there are multiple instances in which the findings literally say that the misconduct led to a lowering of the sale price. So if there is
Where in the decision did it find that the actionable wrongdoing led to a diminution in the price,
so
as opposed to not actionable wrongdoing?
So there are numerous instances of wrongdoing, all of which include the respondents and Mr. Lebec, as you know, is one of the respondents. And so there's the press campaign that suppressed the sale price, and the tribunal says at R99 that press campaign intended to destabilize the sale price, and in fact, that intent was realized. The failure to disclose the HP-MP transaction, which was the direct competitor that ended up sold 3 times higher EBITDA valuation than Fiduciary Network, was improper. And then the Lebec memo, which is the actionable wrong that you're referring to, the tribunal actually stated that it destabilized the sale price and led to a lower sale price than they would have gotten.
There was wrongdoing, but you didn't establish that there were damages with certainty. Because it sold within a price range which was a possibility. Maybe it could have gone for more, maybe it could have gone for less, but you didn't establish that there were definitely damages, even if you did establish that Lebec did things which were wrong.
So when there is, first, the Delaware Chancery Court doesn't require certainty with respect to establishing the amount of damages, only that some damages did exist, and then—
They found no damages. They found there was no duty to disclose the multiple that you're relying upon, which might have increased the value. They specifically found that there was no duty on the part of any of the respondents to disclose that.
That doesn't, well, that doesn't change the fact that their misconduct led to a diminution in the sale price, and that at the end, in the totality—
Again, they found any lack of disclosure was not an actionable wrongdoing.
Well, the Lebec memo—
How can that lead to actionable damages?
The Lebec memo was found to be actionable wrongdoing, and later in the decision, it says the totality of actions taken by the respondents suggests not only intent to lower the sale price, but then, but for their conduct, the sale price was lower.
But,
and
the
so,
thing is, I mean, you're claiming that the tribunal, the arbitration tribunal, did not take this wrongdoers rule into account. And I don't see that from reading this very long, extensive, comprehensive arbitration award, that they didn't take it into account. They did take it into account, but, and if they had found damages, even if they were uncertain, that would have been okay, because the burden of determining the uncertainty of the damages would have been on the wrongdoer. The problem here is, even taking all that into consideration, the tribunal just did not find that there was damages. I mean, there was wrongdoing, and maybe it's frustrating for your clients that the tribunal found wrongdoing and then you got nothing for it, but they didn't find damages. It was unusual, but that's what they found. So they didn't disregard the rule as much as they considered the rule and just didn't get to the result that you might have hoped.
but if you look at the actual analysis with respect to the damages, there's no, the tribunal never says that there are no damages. They say that there is this range of prices that they look to, which happened actually before the misconduct started, so I'm not sure that that's a really relevant thing to look at as a proper range. But they look at this range of damages, which doesn't really even matter, because our client was entitled to the fairer price, but for the misconduct, not just a fair price in some like reasonable estimate. But they compare that against what they view as, you know, flawed expert testimony. That's fine. It doesn't matter if the expert testimony is flawed. The Delaware Chancery Court can devise its own way to make damages, and it can take all of the inputs that it had, and once it found the misconduct, it could award that specifically just to Mr. Lebec, even if that was just one of the respondents to whom the damages could accrue, given the fact that there were these exculpatory provisions.
Okay, let's hear from your adversary, and you'll have a few moments on rebuttal. Thank you.
Thank you, Your Honors. Neil Steiner from Deckert for the respondents. And I believe Your Honors have covered many of the points that I would have liked to cover, but this was an arbitration award. There were 7 days of testimony before a super sophisticated panel. Michelle Riley's an adjunct professor at Columbia. Michael Lambert's the former chief litigation counsel at Cantor Fitzgerald and its affiliates. And Jack Levin is the founding partner of Howard Darby and Levin, a longtime Covington and Burling partner. And they considered 7 days of testimony. They considered extensive pretrial and post-trial briefing. They heard argument, and they issued a 77-page opinion. And as Your Honors have hit on what they said in the opinion, there were all sorts of allegations of wrongdoing, claims that the respondents sought to lower the sale price so that they could exercise the right of first refusal at the end of a process and pay bankers' fees and breakup fees, which they did, including paying $30 million to the appellants and the other minority owners of the company for their interests. And what the tribunal found after all of that evidence and testimony and considering everything was virtually all of the complaints that the appellants made, there was no actionable conduct. And there was one very limited thing, which was that in January of 2018, after 4 bankers had been interviewed, they provided a range of estimates of $95 million to $105 million for the company. After that happened, in January of 2018, Mr. Lebec sent a memo to the investment banker that was hired, copied the other 3 members of the negotiating committee, copied Davis Polk and Wardwell, which was the counsel to the negotiating committee, and copied Mr. Hurley with complaints about some of Mr. Hurley's prior estimates. And what the tribunal said was, well, that would have been more appropriate to have a private conversation with the banker than put it in a memo. 5 months later, in June, Davis Polk and Wardwell told Mr. Hurley's counsel at Ropes and Gray at the time, we think this needs to go into the data room for the remaining bidders in the sale process. No complaints or objections. It goes into the data room. The highest bid for the company is ultimately $110 million. And what the tribunal found, lengthy analysis, was that this sending of this memo, while perhaps actionable, was a limited actionable wrong, and there was no damages attributable to that. And it's in the record 138 and 139 of the record. I think it's paragraphs 244 to 249 of the record is the discussion of damages. They recognize that Delaware allows a lower burden or a lower level of proof for amounts of damages if damages are established, but they say we don't have that here. Everything that we have here points to this limited issue that we found not resulting in any damages, and they don't award any. And as the court...
So, sir, the tribunal acknowledges the wrongdoer rule, and let's assume that they acknowledge it, and they clearly misapply it to the facts before. Would that rise to the level of manifest disregard?
I don't think so, Your Honor. I mean, that's not what we have here, but I don't think that would under, Wien and Malkin in 2006, the Court of Appeals, basically with the manifest disregard standard, set that incredibly highly. And on that, I would like to point out on the law, I know there's usually not much of a discussion of the law, but in the reply brief, the appellants point to Justice Ramos's trial court decision in Da Sang, where he vacated and remanded an arbitration award in 2017. What they don't cite is the opinion that Justice Friedman, you wrote, reversing Justice Ramos and saying there's no manifest disregard of the law here, even though what the arbitrators in that case said was you can't have contractual fraud, you can only have extra contractual fraud, which I think is clearly wrong under New York law, but it's not a manifest disregard of the law.
I didn't think the Sang supported petitioner's position.
Yeah, well, they cited the trial court opinion would have. They missed the reversal, which I think is inexcusable. We actually cited your opinion in our opposition brief that preceded the reply that cited to Justice Ramos. So the short answer to your question, though, Justice Higgett, is I don't believe that even that would rise to the level of manifest disregard, but that's not what you have here. You have a sophisticated, experienced tribunal considering everything and saying there's just no damages here. So any relaxation of damages or not relaxation of damages doesn't matter because there are none here. And we'd respectfully ask that you affirm.
Thank you.
Thank you, Your Honors. So, I mean, although there's a 77-page opinion, notwithstanding, the damages analysis is quite short, and I think the whole point is as was pointed out, it ignores, it addresses the wrongdoer rule, it brings it up, but it does not apply it and allows, even if you, look, as you've heard, I disagree with the findings of actionable wrongs that the tribunal did find. In the totality of all the actions that were found to lower the sale price, and that is a real harm to my client. But even if you just take the Lebec memo, Mr. Lebec should not be allowed to get away with causing what was found to be an actionable wrong, lowering the sale price, and then because there's some speculative issues with the expert testimony and weighing that against the potential range, which we also don't agree makes sense to apply here.
Sir, did they ignore the wrongdoer rule or expressly refuse to apply it? Or in your view, did they seriously misapply the rule?
So I believe that the tribunal knew of the rule and in fact cited the Dole case that both parties cite frequently in their briefs and just knew that that was the rule. The Dole case is actually great for us. The court there went, took multiple different competing types of damages calculations and applied its own and what it thought was the best way to do so. And in doing so, allowed the, person, the party who was the victim of having, whatever diminution in value that they were subject to, and gave them a damages award, having found that there was misconduct that caused harm. And that's all we're asking here.
Thank you. Thank you both. Police Benevolent Association versus the City of New York.
Good afternoon, Your Honors, and may it please the Court, Amy McCampbell on behalf of the Appellant, City of New York. Your Honors, this Court should reverse Supreme Court's order here for two reasons. First, the petition is barred by res judicata and should have been...
You do raise issues which would seem to certainly warrant serious consideration about the fact that it's the police commissioner who has to decide whether or not these police officers can stay on their job in the terms and conditions of employment. But how do you get past the fact of you've had a decision in Staten Island, which, why isn't that res judicata? I mean, you could have raised these issues in that case.
Your Honor, I represent the city, and I agree with you completely that the petition is barred by res judicata.
She agrees.
You agree.
The claims in the proceeding, the claims that PBA alleges here could have absolutely been brought in the Richmond County proceeding, and they were not. PBA declined to pursue an amendment of its petition in that proceeding, and therefore res judicata applies here.
I want to respond to the waiver argument then, that you waived your right to assert the res judicata argument.
I think PBA argues that we acquiesce to them splitting their claims because...
Right, well, that's what I mean by waiver.
Sure, and that's absolutely incorrect, Your Honor. When PBA improperly asserted these new arguments in reply, the city objected because party cannot assert new claims in reply. But then when PBA purported to withdraw the claims that hadn't been properly pleaded in the first place, it's true the city didn't object, but that's not the same as acquiescing to PBA splitting its claims and recycling them in an entirely new proceeding at a different court at a different time, challenging the same vaccination requirement.
Did Judge Colon sort of pull the PBA into this by saying, well, you do what you feel you need to do? She sort of said, well, if you want to start another action, go and start another action.
There was an off-the-cuff remark at the hearing where the judge said, essentially did say, PBA should do what it needs to do to preserve these claims, but the judge pointed out that they hadn't been properly raised because they were only raised in reply. They hadn't been properly pleaded. And then in the final decision, the judge said that the judge was not considering those claims, which made perfect sense because they hadn't been properly pleaded. And it's black letter law that res judicata applies to claims that were brought in the prior proceeding or that could have been raised. And these claims absolutely could have been pleaded in the prior proceeding. As PBA points out, when it first asserted them in reply, that was during the time period when it could have amended its petition as of right under the CPLR, and it declined to do so. Instead, it split its claims by filing a new proceeding in a different court at a different time, and is barred from doing so under res judicata. On the merits, Supreme Court's order was incorrect. Supreme Court effectively held that the city cannot enforce the vaccination requirement against PBA members, NYPD officers, without collective bargaining or legislation. And that's wrong. On the collective bargaining point, first of all, PBA had never pled an improper practice claim. But to the extent—
Why isn't the PBA right that in terms of whether these police officers are to be dismissed, it's not a decision for the health commissioner, it's a decision for the police commissioner?
Your Honor, the police commissioner does have the authority under the city charter to manage the personnel of the police department, and that's what the police commissioner did here. All of the employment consequences for noncompliance with the vaccination requirement were enforced by the police commissioner.
But wasn't it really dictated by the underlying order of the health commissioner?
Well, PBA alleges that PBA raises this new theory that Supreme Court hadn't adopted and that we don't believe any court has ever adopted, that the police commissioner has to act on her own independent policy decisions. And that's simply incorrect, Your Honor, because under it flies in the face of the city governance. The police commissioner is appointed by and serves at the pleasure of the mayor. And the mayor can remove the police commissioner whenever, in his judgment, public interest so requires. So it makes perfect sense for the police commissioner and other agency heads to take directive from the mayor. The mayor directed agency heads to terminate non-complying members of the different agencies, including police department. And here, the police commissioner followed that directive. She had the lawful authority to do so under the city charter.
Undercut the statutory authority of the police commissioner to determine personnel policies within the police department?
Yes, Your Honor, under the city charter. And PBA effectively agrees with that. PBA agrees that the vaccination requirement, quote, falls within the scope of the police commissioner's exclusive authority, end quote, under the city charter. That's page 6 of their reply. What PBA is arguing is that it has to be an independent decision that sprung from the police commissioner's own head. It couldn't have come from the mayor. And there's no support for that theory, and it's completely inconsistent with our system of municipal governance. So PBA's alternate theory for affirmance, it has no basis.
If this is a disciplinary measure, then it doesn't come from the mayor, it comes from the police commissioner.
It's not a disciplinary measure.
Doesn't it have to?
Your Honor, the police commissioner does have authority for disciplinary and measures that extend beyond disciplinary measures, as PBA concedes.
I mean, I understand that the commissioner serves at the pleasure of the mayor, but legally speaking, the mayor cannot say fire this police officer. The commissioner can, after going through the appropriate procedures as set forth in the regulations. The ultimate determination is the police commissioner's. If there's an appeal, if there's a hearing, the ultimate decider is the police commissioner.
The vaccination requirement has not been enforced as a disciplinary measure. It's been enforced as a condition of employment. As Supreme Court noted in a footnote of its decision, claims about due process were not before it. They hadn't been asserted by PBA. And PBA admits in its papers that the scope of the police commissioner's authority extends beyond disciplinary measures to broad management of NYPD personnel. I see I'm out of time. Thank you, Your Honors.
Thank you. You'll have a few minutes on rebuttal.
May it please the court, Matthew Daly for the PBA. The decision should be affirmed. This appeal involves a narrow issue, whether the New York City Health Commissioner—
Counsel, I would agree with you that it raises a narrow issue. And on that narrow issue, can you explain to us why this isn't barred by res judicata? Because I don't see any claims that you raised here that you couldn't have raised in the Richmond County case.
The lower court properly held that this current case is clearly not barred by res judicata based on the record here, and there are two reasons, Your Honor.
Well, we're not bound by what the lower court said, obviously, but—
There are two reasons, Your Honor. These claims were expressly carved out by the Richmond County Court, and number two, these claims—
No, perhaps you can show me the language where they carved it out and said that you could bring them in a new proceeding. I didn't see that they said that anywhere.
So the lower court said that on 2 occasions, Your Honor. The first is in the record at page 318, where after the city objected to the PBA asserting these claims in a reply pleading, not a reply brief, but a reply pleading, and the Richmond County Court said that the PBA was free to start another action.
Well, that didn't say that, but by saying he was free to do so, he didn't say that, I'm sorry, the court didn't say that that had merit. It was said they're free to do so, but didn't opine on whether it would succeed.
Respectfully, Your Honor, the court gave us permission to file the claims in a separate proceeding. But number 2, at page 293, and this is the court's decision, the Richmond County Court's decision, it expressly said that these claims were not being considered by the court. The PBA never had its day in court.
Isn't that because those claims weren't at that point before the court? So how the court couldn't sua sponte consider them?
So at the conference where this issue first came up, and the city itself objected to these claims being asserted in the Richmond County case.
Because they were asserted for the first time in reply. And I'm talking about the claim involving regarding the police commissioner's broad and exclusive authority over police discipline.
Well, first of all, Your Honor, the claims that are before the court today are completely different than the claims that were asserted in Richmond County, and they could not have been asserted when the Richmond County case was brought. And I think that's what the fundamental point here is, and why the city's argument on res judicata is wrong. We filed the Richmond County case in October 2021, before the vaccine mandate even took effect. At that time, the city was not calling it a condition of employment, and the city was not terminating anybody. It wasn't until several months later, in February 2022, that the city first formally announced that this is a condition of employment on all city agencies, and that we're going to start terminating city employees. They had never done that at the time the Richmond County case was brought. And the city is just completely wrong to say, well, we were required to amend our petition in the Richmond County case to assert later arising claims and later arising issues. That's not how res judicata works. When you have a later arising fact, later arising issues, you're not required to bring those in an existing case. You're perfectly free to bring those in a separate case. And that's what the Richmond County judge allowed us to do. And at the end of the day, nobody disputes that these claims weren't decided. They raised important and meritorious issues. And if the court were to rule on res judicata grounds, we would be deprived of our day in court because nobody resolved these issues except for the New York County judge.
But the ultra-virus act, the alleged ultra-virus act by the health commissioner occurred a week before you brought your proceeding in Richmond County.
But it wasn't until February 2022 that the city took this position that it's a condition of employment. We could not have raised the condition of employment issue in the Richmond County case. And that's what this case is about. And that's where I was starting, Your Honors. The narrow issue in this case is whether the city could treat the New York Health Commissioner's order as a condition of employment and use that to terminate police officers. That's the issue before Your Honors, and that issue was not raised and could not have been raised at the time we commenced the Richmond County case. Now, getting to the merits
Why couldn't you have amended the petition in that action to assert those claims?
But that's not how res judicata works.
Res judicata is any action you brought or could have brought. So you have to articulate why you could not have brought that claim in the Staten Island proceeding.
Your Honor, with all due respect, res judicata does not require you to amend an existing case with respect to later arising claims. Res judicata applies when the claims that are asserted, they all arise from the same factual nucleus, but here you have later arising facts, and res judicata doesn't.
There's a case that says that if something changes in the case as it goes on, that you have a right to then bring a separate proceeding, even though it arises out of the same nucleus of operative facts, but occurred later on, that you can then go start a new action?
We cited First Department authority, Your Honor, that says res judicata does not apply when the claims are based on facts that did not exist at the time you brought the first case. That's in our briefing, and that's just what the law is, Your Honor. And again, we could not have raised the condition of employment issue when we brought the Richmond County case. So
when was your reply put in? in Richmond County?
The reply in Richmond County, I believe, was put in January. That's in the record, but I believe it was in January. And again, this is all a product.
Before the new policy was adopted.
Without question, it was before the new policy was adopted. And what we did, Your Honor, is at this hearing where the city first complained about these claims being asserted, the city took it, the judge took it under submission. And then when the city announced that this new policy was coming out, we wrote to the judge and we said, Judge, the circumstances are changing. We need a decision whether or not these claims are going to be asserted in your case, because otherwise we would have a statute of limitations issue. And the judge again referred back to what she said at the conference. Feel free to bring another action if that's what you want to do. So we withdrew the claims without prejudice. The city never objected to that. The city never asked the Richmond County judge to say that these were dismissed with prejudice, that they were ever considered, that they were decided on the merits. The city just sat by quietly. That's complete acquiescence because we said we were going to bring them in another case.
You're saying the city was required to tell you, hey, you're going to have a res judicata issue if you do this, that they were required to disclose that to you? Is that what you're arguing?
If they want to avoid acquiescence when they're the ones that objected to us
They had to
bringing
alert
them
you
in the
to your
case.
own legal dilemma you were falling into by discontinuing the claim?
What they could have done, Your Honor, is they could, when the judge in Richmond County issued her decision saying these claims are not being considered in this case, the city could have moved for reconsideration and said, Judge, we think these were part of the same nucleus and that they should be dismissed with prejudice or on the merits.
That wasn't what they thought. They thought that they could have been within the same nucleus, but that they hadn't been pled, so there would have been no reason for them to say that. And I'm also puzzled by your argument that when the judge said, feel free to start another action if that's what you need to do, that constituted a ruling that any future action wasn't barred by any legal doctrine.
Your Honor, when
I find that a surprising argument that you would think that goes that far.
Your Honor, when you look at the cases that we cited, they're very clear that a court does not have to use the express language with prejudice. And it happens all the time where issues come up during a conference and the judge determines that the proof is going to be different or these are different issues, and parties are given permission to file another action. Whether it's in a written order or it's in a transcript, we follow the court's directives. And
I don't think anybody's saying that you might not have an opportunity to bring another action, but the judge there was not making a ruling on a res judicata issue that might possibly come up. Let's hear, you've spoken a little bit over the time, let's hear from the other side, and you'll have a few minutes on rebuttal also.
Your Honors, I'd just like to address 2 points quickly on res judicata. My adversary was arguing that the condition of employment issue couldn't have been pleaded at the time of the Richmond County proceeding. The Richmond County petition, page 335 and 336 of the record, refers to the vaccination requirement as a condition of employment. It says respondents issued the vaccine mandate, which requires all officers to be vaccinated against COVID-19 by 5 p.m. on October 29th.
What's the date of what you're reading from?
It's their petition in Richmond County. Again, it's 335, 336 of the record, and it is dated October 26th. So the PBA...
His central point, as I understood it, is that what he is attacking today is things which happened months later.
The condition of employment, Your Honor, is something that they were aware of from the get-go, that this is how the vaccination requirement would be enforced. And all of the new matters that they cite in their brief, they all arose before the PBA chose to quote, withdraw the claims that were improperly pursued.
Well, did something new happen in February or not?
It's the CAPA.
I'm sorry?
The CAPA, the public hearing. It didn't arise
sure.
After the
yes, and that had happened before they submitted their February 8th, 2022 letter. And PBA says at page 41 of their main brief that they could have amended their petition as of right at the time that they filed their reply, but they declined to do so. So what PBA did here, it split its claims, it's brought different claims challenging the same vaccination requirement at a different time in a different court, and res judicata prohibits it from doing so. I'd like to just go quickly back to the merits, Your Honor. Again, collective bargaining, the Supreme Court erred in ruling that that was required here because as we've explained in our papers, and PBA has not rebutted, the court did not have jurisdiction to address collective bargaining in the first instance. That lies with the Board of Collective Bargaining, and Supreme Court...
You hadn't raised that issue
No, Your Honor, because PBA hadn't pled an improper practice claim. Supreme Court ventured into that realm on its own, and it was incorrect to do so. And again, legislation is also not required.
What's the authority for adopting new conditions of employment?
Well, the authority for the police commissioner...
Without negotiation, without collective bargaining? I mean, can the police commissioner just decide on any given day there's a new condition of employment?
So under the city charter, Your Honor, the police commissioner does have broad authority to manage police personnel without collective bargaining or legislation. The city charter, it's 434, and there's a string of cases.
So what things would require negotiation and collective bargaining?
What requires collective?
What type of requirements would fall under a need for negotiation and collective bargaining?
That would have to be brought before the Board of Collective Bargaining in the first instance. The Supreme Court doesn't have original jurisdiction to address the need for collective bargaining, and PBA hadn't pled such a claim. So Supreme Court's order, the stated basis for its order on the merits was incorrect, and PBA's alternate theory, the independent policy decision theory, has no basis and is inconsistent with our system of governance. And unless Your Honors have any further questions, we ask this court to reverse.
Thank you.
Thank you.
One quick point on the res judicata issue that I respectfully submit as dispositive. There's nothing in the record where the city called this a condition of employment or started terminating police officers until February 2022. The Richmond County case was brought.
But she indicated that you called it a condition of employment in the context of your petition.
But it was not declared by the city as a condition of employment until February 2022. There was no way to know at that time until later that the city was going to deem this a condition of employment by the health commissioner. That issue could not have been brought when we first brought the Richmond County case. I want to get to the merits, Your Honor. This notion that the city is now hanging their hat on, that this was an independent policy decision of the police commissioner, is completely different than the case that they presented to the trial court. It's completely different than the arguments they've made in courts throughout this state. The position that they have taken, and they're stopped from disputing this now, is that this was a condition of employment created by the health commissioner, and that's what the record shows. This was imposed on all city agencies. This was not an agency by agency decision. And in fact, the city submits an affidavit, and in that affidavit, they say the mayor directed the termination of all city employees, and that termination take place in February 2022, again, well after the Richmond County case. But on the merits, this was a directive that came down from the health commissioner and the mayor imposed on all city agencies. And that's the issue for the court to decide today. What's the basis of authority for either the health commissioner, the mayor, to require every city agency in this city to create a new condition of employment for their employees and to require termination for noncompliance? This case has nothing to do with bargaining. We're not asserting an improper practice claim about the implementation of the vaccine mandate. This case does not involve a management decision by the NYPD. The NYPD was just doing what it was told to do. Everybody was told that this is a condition of employment by the health commissioner. And now on appeal, the city doesn't even dispute that the health commissioner doesn't have authority to do this. So they're stopped from changing their position now. They don't even dispute the lower court's holding. And in that sense, on the merits, this is a very easy case for the court. Thank you, Your Honors.
Thank you. Thank you both. The next case for argument is People versus Mahoney. Good afternoon. You may proceed.
Good afternoon. Sam Claflin for defendant appellant Anthony Mahoney. Mr. Mahoney's sentence is excessive. He faced the court as a 22-year-old with no priors whose conduct arose in the context of housing insecurity and substance abuse.
Counsel, he also faced the court as somebody who was was convicted of assault that caused the victim to go blind in one eye. Isn't that something we can consider in terms of deciding whether or not this sentence was excessive?
Yes, Your Honor, the facts of the offense are certainly something this court can consider, and we, of course, acknowledge that the harm that the victim suffered was extremely serious in this case, and indeed serious under the offense to which Mr. Mahoney pled second-degree assault. So by the time of sentencing, however, Mr. Mahoney had already completed extensive rehabilitative programs.
And that was the agreement, I think, that he would just get probation if he did that, and all he got on this claim was probation, which I believe the term of which is to expire this coming fall, correct?
Yes, the term is set to expire this fall, Your Honor, and indeed that was the agreement. However, under Thompson, the fact that the sentence was reached by a negotiated plea is but one factor for this court to consider in analyzing whether a sentence was excessive. So this court has a plenary power to determine that the sentencing court below got it wrong. And here we believe the sentencing court below did get it wrong, because by the time of sentencing, Mr. Mahoney had completed extensive rehabilitative programs to reduce his recidivism risk. He had gotten a job, and he had resumed living with his close-knit family. As to the rehabilitative program specifically, I just highlight that by the time of the plea, he was volunteering 5 days per week with the Cases Court Employment Project's substance abuse rehabilitation program. He had resumed living with his mother, sisters, nieces, nephew, and stepfather, with all of whom he had a close relationship. He had a job lined up. And then, importantly, as Your Honors have already acknowledged, he did a full year with the Fortune Society pre-sentence, and he did exceptionally well in that program, as the prosecution acknowledged. That program focused on substance abuse treatment, providing stable housing, obtaining employment, college enrollment.
His completion of that program was a condition of his probation. So if he hadn't completed the Fortune Society program, he would have been facing incarceration. So while it's laudable that he finished it, there was certainly some pressure on him to do so, correct?
Yes, certainly, Your Honor. Nonetheless, our position is that because his rehabilitative successes were so significant that ultimately the full probation term that he received was unnecessary in this case.
He pled guilty to assault 2. What's the minimum sentence for assault 2?
The minimum? I believe 2 years, Your Honor. But there's an opportunity for a...
How did he avoid incarceration on this case?
Sure. So I believe below the sentencing court needed to pronounce that Mr. Mahoney's sentence was going to be concurrent with 1 day's jail in order for him to obtain the 5 years of probation that he received. We go through the relevant penal law provisions in our reply brief, Your Honor, in response to the prosecution's contention.
It seems like there's some question whether this was even a legal sentence in terms of its leniency.
Respectfully, Your Honor, we believe that that's a red herring in this case because, again, the court and the prosecution determined that a straight probationary sentence was appropriate. And because, again, all the court...
Of course, the legislature may have disagreed in setting the penalties for the offense to which he pled guilty.
Indeed, Your Honor, the court should have stated that the sentence was going to be 5 years of probation to run concurrent with a single day's jail time, if indeed the court believed a straight probation sentence was appropriate. Mr. Mahoney had over 20 days of jail credit by the time of his plea, as the prosecution acknowledges. So, indeed, he didn't receive a windfall, as the prosecution suggests. Rather, he got the sentence that the court deemed appropriate.
I read the prosecution's suggestion is that really the sentence that was ultimately pronounced was not a legal sentence, and he had the benefit of that.
Well, so again, he didn't receive any benefit because all the court would have needed to have done was say that the sentence was to run concurrent with a single-day jail sentence, and Mr. Mahoney had already satisfied 20-fold that amount of time by the time of his plea. So again, he had done exceptionally well in the Fortune Society's year-long program pre-sentence, and then served
But the sentencing judge was certainly aware of all this. I mean, I know we can take another look, we have de novo jurisdiction, but the sentencing judge certainly was aware of this.
Yes, Your Honor. The sentencing judge was aware.
Okay, let's hear from your adversary, and you'll have another moment on rebuttal. Thank you.
Good afternoon, Your Honors. May it please the Court. Elliot Hamilton for the Office of the District Attorney in Bronx County. As your Honors have pointed out, yes, this was a sentence which he ended up completing 5 years of probation after completing programming with the Fortune Society after he pled guilty to a Class D violent felony offense. For if he were to fail that Fortune Society programming, he was to be sentenced to 2 years in state prison, followed by 2 years of post-release supervision. I think it's important for the context regarding this case that the defendant was indicted on the top count of assault in the first degree, a Class B violent felony offense, where he faced a mandatory minimum of 5 years in state prison and a maximum of 25. So this was a serious case, not only in the fact that the victim lost vision in his eye, but he also suffered facial fractures that required surgery. The totality of the circumstances of this case resulted in the plea that as well as the defendant's substance abuse issues and his housing issues, those were all taken into consideration when the people offered the repleader situation that the defendant had to complete Fortune Society programming for a period of time before sentencing or else face the risk of incarceration. To the defendant's credit, he did complete all of that. He did get 5 years of probation sentence, despite the fact, as your honors pointed out, it was facing a mandatory sentence of 2 years of state prison on that count as well. I'll just quickly state with respect to the waiver.
So what's your response to what defense counsel says that if they had pronounced that it's concurrent with 1 day of incarceration, that would have cleared up the problem?
I think the issue is that even for a case for a D violent felony, the legal sentence prescribed by Penal Law Section 70.02 prescribes a mandatory minimum of state prison So I don't think the issue of having him being sentenced concurrent to 1 day would have changed the fact that by statute he had to face prison time as a result of that. He did benefit as a result of this plea. He benefited by his own programming as well, and he should be bound by the terms of that sentence. And if the court has no further questions, we ask that you affirm.
Thank you. Counsel, you have 1 minute on rebuttal.
Just briefly, a 2-year minimum was not required under the penal law. Again, a diversionary sentence was possible. We go through the relevant provisions of the penal law on page 6 of our reply brief in order that detail how that sentence would have been possible, though again, the 1 day concurrent with jail time would have really cleared all of this up. As to the point that this was all before the sentencing court, that's of course true, but of course this court has a plenary power to determine that the sentencing court's sentence was harsh and excessive.
Sir, to what extent should we factor in that his maximum exposure was, well, that if he was exposed to the top count, it would have been a 5-year minimum, 25-year maximum?
That's a factor that this court can consider, Your Honor, but the mere fact that Mr. Mahoney, in this counterfactual could have been convicted under the top count is not dispositive of whether his sentence was appropriate. And here, again, we believe that under the facts of the offense, and especially given Mr. Mahoney's unique rehabilitative successes pre-sentence, that the sentence was harsh and excessive. Unless Your Honors have any questions regarding the purported waiver in this case, then we will rest on our papers, and we ask you to reduce the sentence. Thank you very much.
Thank you. Thank you both. And the last case for argument is GNY Maintenance versus Core Continental.
Good afternoon, Your Honors.
Good afternoon.
I'm Jerry Toth, representing GNY Maintenance. The complaint alleged particularized facts. Firstly, that Chong requested proposals annexed to the complaint as Exhibits A and B.
I'm going to ask a very specific question, which is about the accounts dated claim and whether or not it is time barred. And why is it not time barred? When are you stating that the accrual should run from?
Okay, thank you for asking that. Certainly, we have 3 reasons why it's not time barred. Firstly, in the case of
Ellie?
Ellie?
okay, the due date of the accounts of the invoices was March 31.
And do you have any cases that specifically say that the statute of limitations for an account stated runs from the due date stated in the invoice?
Certainly. John Kastner v. City of New York, the Court of Appeals noted that normally in a contract case, the claim accrues at the moment of default. In Verizon v. Sprint, the First Department quoted John Kastner and found that, in finding that the date of the due date of the invoice, before the due date, the plaintiff could not know if he had a cause of action or not.
Well, sir, Kastner refers to a condition, that the demand is a condition to payment. Was there such a condition in this case?
No, but the principle is the same. That
Okay, and
the
are you
moment of
aware
default-
that our Verizon decision has only been cited one other time and has been heavily criticized by federal case law as being inconsistent with Kastner?
Well, this court stands independent of federal law, although you can respectively consider federal law. But I think your decision makes a lot of sense, that the due date of the invoice is the date when the defendant didn't pay the invoice, when the cause of action accrues.
But then that's inconsistent with Kastner, that says where it's a condition.
Okay, in that case...
But you just said there is no condition.
In that case, the default occurred when the condition was satisfied, when there was, I think, an audit or an inventory or something. But in this case, the default occurred when Chong did not, when Core did not pay the invoice in full on March 31. Now, secondly, in the case of Lou Morris Demolition v. Department of Education, the First Department ruled that in some circumstances where there's a partial payment and a complete, unequivocal, unqualified acceptance and promise to pay, the statute of limitations is told. So that circumstance, on a motion to dismiss, the court is required to consider affidavits in opposition to the motion to dismiss, and that circumstance raises an issue of fact, whether the statute of limitation was told. Furthermore, there's a third reason why the court below should be reversed, is that in this case, the doctrine of equitable estoppel applies, in that Chong repeatedly represented that he would pay, promised to pay, and the facts in the case support the affidavit of Jin Lao at paragraphs 18, 60, and 61, where he says he met with Core and Core repeatedly promised to pay. Core deceived him. He relied on Core's promises, and the GNY did not file mechanics liens until 6 months later in September. During all that time, GNY relied on the false representations. So there's let's see, in General Stencils v. Chiappa, the Court of Appeals said,
How is that anything other than a breach of contract?
Excuse me?
How is that anything other than a breach of contract?
When you say that, you mean the promises to
Say
pay?
He told him he's going to pay, and he didn't pay. How is that not a breach of contract?
Okay,
And your breach of contract cause of action is still in this case.
great question. The issue is it's not simply a breach of contract. This is an extraordinary case in that GNY at 3 construction sites.
You say this fraud because he told him he would pay and he didn't pay. But telling someone
no,
you're
he-
going to pay and you don't pay, how,
Okay.
Wait. Let Judge Friedman finish his question.
Absolutely.
how is that anything other than just a breach of contract?
Okay, at the time Chong represented that he accepted GNY's proposals, he misrepresented his intent. A misrepresentation of intent is a misrepresentation of present fact.
There weren't any payments made here by CORE? CORE made no payments after after plaintiff started doing the work?
Yes, the Lau affidavit describes Chong modus operandi.
No, am I right? There's no question that CORE made payments. The dispute is whether CORE paid everything that CORE owed, but CORE did make payments.
Well, the allegation of the complaint is that CORE practiced deception. He represented that deceptively that he accepted plaintiff's proposals, and then he cheated the sub by underpaying him.
But under Simkuski and Putter, deception alone isn't enough to trigger equitable estoppel, is that the conduct has to be such that it essentially prevented the plaintiff from commencing a timely action.
Well, here we have representation, falsity, scienter, reliance, and damages. These 5 circumstances unquestionably support a cause of action for fraud. On a motion to dismiss, the issue was not whether plaintiffs stated a cause of action, but whether he has a cause of action. And Chong's misstatement of present intent was clear case of a gross and outrageous fraud.
Okay.
Methodical and calculated and repeated.
Okay, let's hear from your adversary, and you'll have a few moments on rebuttal. Thank you very much, counsel. 7, same as the appellant.
Using up his minutes.
May it please the court, my name is Brian Levine, and I represent the respondents, Core Continental Construction, and Chunlin Chiang.
Can you focus in on this whole issue about when does the statute of limitation accrue on an account stated? It says it's supposed to be the last transaction. And what is the last transaction? It's been hard to find a case. Is it the actually sending out of the invoice or something else?
Absolutely, Justice Kaepernick. As Justice Gesmer and Justice Kern mentioned, there was Eli International, and if there's any case that makes it very clear of when the statute of limitations accrues, it is that case. In that case, the plaintiff.
Tell me how that case makes it clear that the statute of limitations is counted from March 1st and not March 31st. How does that case clarify that issue?
So, Justice Friedman, in that case, the plaintiff sent out invoices, the plaintiff sold goods in, February 15th, 2003. They failed to send out invoices or demand payment for it until July 2010. The first department held that the statute of limitations ran beginning February 15th, 2003, when the goods were sold, irrespective of when.
What would that mean in this case? What would be
That
the
means
last
that the moment that
transaction in this account when they issued a change order?
the last transaction in the account is at the point where the consideration that is memorialized by the invoice is performed.
So when the actual work was done, not even when the
Yes,
invoice was issued?
Which leads to the conclusion.
Would really the date would be before March.
100%, and that's the thing here. And so giving the benefit of the doubt, every possible favorable inference, we would assume that the
What is
latest
the date in this case?
I'm sorry?
What are you arguing is the date in this case?
The 1st of March, the same date that the invoice is.
So you're saying really you think it might have been before? What you're saying is was really when something was done, but since we're not sure exactly what that date, you're giving
have
them
to
the
give them
benefit of the doubt till the date that the invoice was issued?
Absolutely, yes.
Because with the March 1st date, there's no question it's not timely.
Yes.
So what puzzles me about that, I'm sorry, go ahead.
I'm just trying to figure out why you're arguing March 1st as opposed to the date of the change order being issued, or when the date that the work was completed.
Because that would all come beforehand, and I'm giving him the
No, I
benefit.
understand that, but if we're applying the case, which talks about the last transaction is not when the invoice is issued, it's when the last transaction work was done. So what I'm trying to ascertain is what date that is in this case.
I would love to say it was well beforehand, and we believe it was, but for the purposes of account stated, for this cause of action, on a motion to dismiss where they get the benefit, we have to assume the latest date, and that's the date of the invoice.
And who sent the invoice?
They claim to have sent it.
Okay, and so if they sent it, they could put whatever date they want in as the due date for payment.
Yes, and that's the whole point of why it can't run from a random date that they select, because they could just extend the statute of limitations well into the future, years into the future. And if that were the case, then the court, the First Department, would have held that the statute of limitations in Eli International would have ran in July 2016, because they only first invoiced and demanded payment for the goods.
That seems to me commercially surprising in the sense that somebody who wants to be paid isn't likely to put a due date that's 5 years away. Obviously, somebody can make a mistake and do that, but I guess what troubles me about your argument is that if the invoice was sent out on March 1st and has a due date of March 31st, isn't it reasonable that if there were a lawsuit begun to collect that invoice on March 2nd, the defense would be, it's not due yet. So how can it both be, what does it mean to set a due date if the person is liable to be sued before the due date?
Because you're generally sued for breach of contract. This isn't account stated. They're totally different. This is based upon the fact that they sent an invoice, it allegedly was received. And
so are you saying that from the moment the invoice goes out, that they can be sued the next day, even though the invoice says it's not due for a month?
If they're going to bring an account stated cause of action.
So you're saying that despite the fact that they state a due date, that they can sue for it before that due date?
So then you would come into questions of reliance and whether they're stopped from arguing that because they put a due date that was further out. That would go towards the defense. That doesn't go towards whether they can extend their cause of action.
Counsel, I wonder if you could address briefly, it was the last thing that your adversary was speaking about on fraud. I mean, this is a 3211 motion, so we try to give all the benefits to the plaintiff. Did he state did he state a cause of action for fraud?
So really what he was talking about with fraud, because he didn't answer the question that was asked of him and he just went on, but what he was referring to with that aspect was the estoppel argument. But that doesn't apply because the logic is flawed. For the estoppel to apply, he would have to have waited because of the reliance for filing the lawsuit into 2020. If anything, that might have been an argument he could have raised for why he might have timely not filed a mechanics lien.
But the mechanics lien was filed in 2014. I think it got dismissed on certain basis, but it was was 6 more years almost until he filed this lawsuit.
Absolutely, and that's why that argument is flawed and it doesn't make any sense. But with respect to fraud, there is no fraud claim that was made. One, there's a standard of, a heightened standard for pleadings when it comes to fraud, that this complaint certainly does not meet that heightened standard. And two, it is well settled law in the state of New York as well as in this department that fraud cannot be based upon a breach of a contractual obligation, particularly when it comes to promises to make payments when that payment is owed under a contract. It has to be an independent duty, extraneous to the contract. And so there cannot possibly have been a fraud claim that was properly stated, even on a 3211 motion.
Okay, thank you, counsel. Mr. Toth, you have 2 minutes on rebuttal.
Now, respondent has still offered no explanation why in this case their $2.7 million order of construction work and Chung never signed anything. Moreover, respondent claims that all the work was completed on March 1st, but the motion court determined that all the work was completed on June 4th. And there are uncontradicted affidavits by Jin Lao and the verified complaint and the affidavit of Chung Yaopeng testified that he worked in April.
So this is work which was billed in March that wasn't done until April or June? Is that what you're saying?
Okay, my client knew that CORE takes months to pay. Therefore, he invoiced rather early. But
So you
at
mean
the earliest,
you wanted to be paid in advance for the work?
no, he didn't expect to be paid in advance, and he certainly, in fact, he was never paid. He invoiced $148,000, and he got paid $15,000. So,
But what about the notation on the third invoice saying work is complete? Isn't that inconsistent with what you just said?
not in any respect. That invoice concerned. Sorry if I'm not. If I'm being a little straightforward, but that invoice only concerned putting oil into a generator, but the other two invoices concerned piping from a cellar up
There are
about
3 invoices.
15 floors to the roof.
There are 3 invoices.
Yes.
On March 1st, are they not?
Yes,
For you
and
to get to this total.
And the second and third invoices do not contain that statement that the work had been done. And
This is confusing. This is simply confusing the accrual for breach of contract on the one hand and accounts stated on the other, right? If you had brought this as a breach of contract cause of action, this particular one we're talking about, then we would measure accrual from when the work was complete or substantially complete. But it's an account stated, so now we have to ascertain, circling back to where we started, what was the last quote-unquote transaction for the purposes of applying an account stated cause of action?
Absolutely. The last transaction was the date, March 31, when CORE didn't pay the invoice.
But are you saying that there was work performed after that date
Absolutely.
for that change order?
The motion court determined that, and he didn't file
are
a
you
motion.
arguing
He didn't appeal it. He's bound by that.
Why aren't you arguing that it accrued even later?
Could you repeat that?
Why aren't you arguing then that it accrued even later when the work was completed?
I'm saying the earliest date that the cause of action could have accrued was March 31. In fact, I would argue that.
Why didn't you bring that as a breach of contract cause of action? Why did this become an account stated cause of action rather than a breach of contract?
The two different
You were
causes.
hired to do the work, you did the work, you weren't paid.
The two different causes of action. As my colleague mentioned,
I understand your first
contract
cause
is
of
different from
action
account.
is breach of contract under the oral contract. But then you have this account stated, but why is it brought as an account stated when it sounds like it's a breach of contract?
Well, those are not either or. You can plead both breach of contract and.
You didn't plead breach of contract as to this at all.
Certainly, we pleaded both breach of contract and.
But wasn't the breach of, wasn't the breach of contract for a different amount than this amount of the original oral contract? That's what you claimed breach of contract. And then there was a change order, and the change order the causes of action you pled as to the change order are unjust enrichment, quantum merit, and accounts stated. So it's different causes of action for different things.
Yes, the first two paragraphs of the complaint state on the contract and on the change order.
Well, you know what, we're going to take a look at those the contract and the rest of the paper. So thank you for bringing out all these issues, and we'll try to get to the bottom of it. Thank you both very much.
I thank you for this extraordinary opportunity for the cause of justice.
Thank you. Have a nice afternoon.